Judgment in WPC 6840 of 50.
In view of the reasons recorded here in above, in the considered opinion of this court, this is a fit case where this court should exercise its extraordinary power under Article 226 of Constitution of India to set aside the FR number 109/2024 dated 25/4/24 and direct the CID State of Assam to reinvestigate said Sanmari PS case number so and so, ordered accordingly. It is further directed that investigation be monitored by an officer in the rank of Superintendent of Police in CID Assam. It is expected that CID State Assam shall complete the investigation within a reasonable period of time. A copy of the order be forwarded to the Director General of Police Assam for his perusal so that such lackadaisical investigation done by his officer is brought to his notice and necessary corrective measures are taken in this regard. A copy of this order also be forwarded to the jurisdictional judicial magistrate.
Highly available.
Just some corrections will sign a little bit later.
Let last two lines lordship, that will do. That will do lordship.
That's why we have given.
Lordship.
Accordingly, for reasons recorded herein above, this court finds no merit in this petition to persuade it to exercise its power under section 482 CRPC to quash the proceeding of complaint case number 208C 2006 under section 138 of the Negotiable Act. Accordingly, present criminal petition stands dismissed. Interim order, if any, stands vacated. The learned magistrate shall now proceed with the case.
Any date, man?
You want a date?
Up to your lordship.
No, if you say that any date, we can, again, it will otherwise delayed.
Intimate the court lordship.
You intimate, then let it proceed.
Merit not effect.
Huh?
Merit should not be effect, madam.
No, that is already we have made it clear.
All right. Lordship.
Like to mention item number 1.
Item number
1.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on. Give a date 2009. After vacation.
Yes.
May it please your lordship. I beg to mention item number 10, my lord. Today, my lord, my senior has some difficulty. Senior counsel K. Agarwala is leading in this case, my lord.
10, same order. Give a date. 2017.
Maybe on 23rd, on the day.
We will not say 23rd. She will give a date. 24th.
Oblige the lordship.
Please, Lordship. Lordship, I think of a criminal revision petition for hearing, Lordship.
Which year?
2023, Lordship.
Not this bench. You go to the other bench. This bench is taking up matter up to 2019. Yes. Yes, Vishwas.
My lord, the case in nutshell is this, my lord. My lord, there is an allegation. There was a football match, my lord. Now, a fight broke up between two parties, between one party on one hand and the referee on the other hand. The referee is the injured victim here in this case. The referee and his brother. The referee, he's being examined as PW2 and his brother is examined as PW3. The allegation, the FIR was lodged on the incident took place on 30/8/2001. The FIR was lodged after 2 days on 1st of September. Now, my lord, in the FIR, as many as 19 accused persons were named. Charge sheet was filed against 7 accused persons. Conviction was awarded against 1 person. That is the petitioner before your
What is the special material against the petitioner?
My lord, the special material, the learned court below has the PW2 and PW3, they are the victim and they, one of them have implicated me. PW2 and PW3. PW2 is the referee who was initially assaulted. Then PW3, his brother came to the rescue of the PW2. And then he says that the present petitioner has also assaulted.
India's examination of Steve,
My lord.
did they only accuse you or the other accused also?
Now, my lord, the injury part is regarding me.
Hmm.
Now there is one eyewitness who has been examined. Well, just bear with me I'll just complete the sequence, my lord. 10 witnesses total examined.
Hmm.
Now, out of these 10 witnesses, 3 witnesses were independent witnesses. Now, all these 3 independent witnesses turned hostile. Now remain, out of 10, 3 turned hostile. Now remain the 2 victims, and the other eyewitness is the nephew of the injured person. Now, the nephew of the injured person, who is an eyewitness, his statement in some material point is not corroborating with the statement of the injured witnesses.
Hmm.
The FIR got diluted when it came to their deposition before the court, and the deposition of the injured witness got further diluted by the other eyewitnesses, and 3 of them, they totally, my lord, turned hostile. Now, my lord, they say that the petitioner has assaulted PW2 with an iron rod on the head.
Hmm.
There, the medical, my lord, the MO, the medical officer did not find any such injury on the head of PW2. He said that I have seen PW2 restless. Therefore, I think he might have suffered some head injury, and therefore referred to this Guwahati.
Hmm.
Now, he says, PW2 says that in Guwahati, I got treatment in international hospital. No document of international hospital, my lord, exhibited. PW,
After vacation.
I was trying to locate, my lord, whether this petitioner is alive or dead.
You locate it in the meantime, you locate it. We'll
Well,
have to, the way you are arguing, it will take some time, and
There
Mr.
are 19 accused, out of which, my lord, 7 persons are seated. Only the present petitioner.
Your why, that is what we want to
Yes, my
know.
lord, there are, because some of the specific on PW.
So therefore, there might be a confusion, doubt actually who is the perpetrator.
Absolutely. I
That
was
may
about
be
to come
the,
to
that
my
may be the
argument.
case. And to give him an acquittal, you need to go each, and to dismiss him may not be so much of necessary concurrent finding.
The effect is by a losing team members of.
Members,
team
and
of
who
the
is
football
that
match.
team? Why only out of 9 persons, 1 is pinpointed? What are those cleansing materials on the basis of which he can be? This is your case after vacation.
My lord, your lordship is fixing any date or simply after vacation? Then
We-
after Bihu vacation.
After Bihu, this is 2010, na? Why not before? Before
Bihu
Bihu,
would
it's
be March,
are done with this. After Bihu vacation, give a date. By the January, we should at least complete up to 2011. Yes, Mr. Singh. Any complications? Any complications?
No, only thing is that the CRPC has not been followed, my lord, in this case.
Okay.
Let CRPF matter, my lord. which was
Okay,
this-
okay.
AGI, Architects is appearing. He's on legs.
Okay, give a date. This case is a little important, and we'll,
He's coming.
no, not today. We'll like to take up this. Yes, Mr. Singh, as per your convenience.
My lord, on
I have been informed that these last 2 days, everybody is busy in motions. Why should they be bothered with long hearing? Possible, Muslim? 21st or 22nd? 22nd. Okay. Simple issue. Because on that day also he said he will satisfy. So his fundamental case is that procedure is not followed. On one day, everything is done. Everything is done. Whether that then mandate says CRPC is to be applicable. If applicable, at least he is to be given a chance to not pleading guilty, leading evidence, cross-examination, everything will come.
defense counsel.
Defense counsel. Yes.
20. Sorry, my lord.
21st. Possible.
Your punishment is 3 years, Lordship.
Hmm?
3 years punishment under section 325, 149. On last occasion also non-APS.
Non-APS.
Whereas in this case, Lordship, the injured person is examined as a PW 8
Hmm.
and he identified specifically this accused person.
None appears for the petitioner on call. None did represent the petitioner when a matter was called on 9/6/2020 and on 9/6/2022 and also on 24/6/2020. Earlier is 9/6/2020 and 24/6/2020. In view of the aforesaid, and so we appointed as a amicus. Then rest of the order, give a date. Please this matter and all, list per letter part will be registered to reflect the name, give record. Yes, next.
Five.
B. Sharma. Amicus. Same order, none appeared. None did represent the petitioner when the matter was called on the case of R. Dhar. Why he otherwise he when the matter was called on 5/6/2020. Okay. MS B. Sharma. No time being. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed. This is 2011. 27th of January 2025. Yes. Yes, Sabrabati.
Petitioner before lordship,
Mm.
he filed a complaint
Mm.
and complaint proceeding initiated and it reached the stage of defense evidence lordship. Lordship may peruse page 15
Yes, 15.
in lordship. Day
Mm.
when the matter was fixed for defense witness,
Mm.
the defense filed a list of four witnesses. The petition, petition number 3058. This is the petition filed before the Lanet Trial Court, the list of witness, defense witness. And on the same day, Lordship, this petition was withdrawn as not pressed. So originally it's on page 16, Lordship. Lordship will find that this petition is not pressed. The handwritten copy,
Where?
page 16, Lordship.
Page 16.
The handwritten copy, Lordship. Below, Lordship. This petition is not raised by
Where do you get page?
page 16, 16, Lordship. 16,
This petition is not pressed.
yes,
Okay.
left hand side, Lordship.
Okay,
This was
then,
withdrawn, on the same day, Lordship, by page 17, they filed a petition under section 311 of the CRPC, praying for recross examination of the prosecution witnesses. So we objected to that, and the Lanet Trial Court by page 19, Lordship, order dated 19/10/2012, was pleased to reject the prayer for recross examination
Mm.
made by the defense. This order at page 19 has two part, Lordship. One is rejection of the
recross.
rejection of recross, and the last line, Your Lordship, page 20, last line, fixing for DWs on 2/11/22. The last page 20, last line, Lordship.
Mm.
Last part of the order. Is accordingly, petition is rejected, fixing for DW on 2/11/12. Here, Lordship, what I would like to submit, as because they have withdrawn the petition, the list of witnesses. So the Lanet Trial Court ought to have fixed the matter for argument, because they are not inclined for adducing any.
And this matter is pending on this point since then.
No, Lordship, no, Lordship, further. So this, I was aggrieved, the petitioner was aggrieved.
So you have come before.
No, what happened, due to the rejection of 311, they have also filed a revision for the sessions. The impugn order, this is not the impugn order, Lordship. Lordship will find the impugn order at page 24. Both the complainant also filed revision and the defense also filed revision. Because they are
You file revision against
that part,
that part,
and
that,
they have filed revision.
and that this was common judgment also. Where is that?
Page 24,
Page?
24. It starts at page 24. Our revision was 55 and their revision was 62.
It is a common judgment.
Common. By the judgment, what happened? The learned session judge has allowed the cross examination, recross examination of the prosecution witnesses.
What is the ground?
Lordship, what I'll be submitting, Lordship may.
Where is the ground of, what is the reason is recorded, huh?
No reason, Lordship, because page 17, the original petition, there's nothing on.
No, we'll come to that later on. How, that we understand. They have simply said that I want to recross examination. Why, what is the, why happened? Nothing is there.
Nothing.
And the magistrate has passed this order that there is nothing disclosed. Why should I allow the recross examination?
Now-
It cannot be as per mayor. Now, how the session judge deal? This is,
Now they develop the case.
forget, I am asking Mr. Chakraborty, what is the finding of the learned session judge in the record, in
Session judge held that material.
what is their ground will come later on. How this kind of situation was dealt by the session judge in the impugn order.
Consider that fairest of fair trial should be given to the accused person. And here they have stated that what was the weapon used, everything was not asked. And the session, they developed the story by saying that two grounds. One, new counsel has been engaged by the defense. This is one ground. And second, that they stated in the petition that what was the weapon used, that material cross was not done by the earlier counsel. They have stated, judgment states that. And the learned session judge held that fairness of trial should be given to the accused person. So
No, death is the ground. What is the finding?
finding a lost will find. Learned session judge has considered the case of P. Sanjeeva Rao at length, Lordship, and then Lordship. At page 34, Lordship, little part. For the mistake of previously engaged learned counsel is in not cross-examining the witness on these points, accused should not suffer, and it cannot be a ground for disallowing the prayer, else credibility of the witness would not come out. In a criminal trial, the accused should get every opportunity to have a fair trial. On this point, the Honorable High Court observed such and such.
Which space?
Page 34, Lordship. Inner page 11. Okay, first paragraph from the middle, it starts for the mistake.
Or the mistake? Where?
Fifth line, Lordship, fifth line from top.
Page 30?
34, fifth line from the top.
Who is representing the other side?
The appearance, Lordship. Upon the learned second judge heavily relied upon the judgment of P. Sanjeeva Rao. In that case, what happened, Lordship?
No, we'll come to this. Just let us understand what is his reason. He may say P. Sanjeeva Rao given, but what is the relevance in this case?
Exactly, Lordship.
But why I am asking you, where is the discussion?
Lordship, the learned.
Well, here you want merit, but I want to understand why this petition was allowed. What is the reason for allowing?
It starts from para 11, Lordship, at page 31.
Para 11.
I've gone through the aforesaid case laws and found that such and such honorable prayer under trial on the facts and circumstances of the case in which matter was challenged in Hanuman such and such discussed and power of the under such and such.
Oh, these are the principle of law.
Yes.
Where is the findings that these facts are available to allow? Nothing.
Nothing is there.
Hard.
Nothing is there. Only they discussed.
That is what I'm asking. That's all. We need know nothing, all these elaborate things. Hard, Mr. Chakraborty, learned counsel for the petitioner, also heard Mr. Bhattakur, learned additional public prosecutor. None appears for the respondent number.
2 and 3, Lordship.
Respondent number 2 and 3. First up, the petitioner as complainant has preferred a CR case.
Name the phone. No, their name also not shown in the court list. Madam.
Service completed. Though none appears for the respondent number 2 and 3. Though as per office note dated 27th and 22/7, notice has duly been served upon them. Okay. The present petitioner preferred the present application is filed for quashing the order dated 17/6/2013. Is that it?
Yes.
Passed by learned session judge Morigaon in criminal revision number 55/12, preferred by the petitioner. The common, and just give it like that. The common judgment, and common is not it?
Yes, common.
This common judgment and order dated 17/6/2013, passed by the learned session judge Morigaon in criminal revision number 55/2012 within bracket, preferred by the petitioner, and criminal revision number 62 of 2012, preferred by the respondent number 2 and 2. 2 and 2. Whereby after setting aside the order dated 19/10/2012, passed by the learned magistrate, the prayer for re-cross examination of the prosecution witnesses were allowed by the learned session judge in exercise of its revisional jurisdiction. The brief facts of the present case is that the petitioner preferred criminal complaint which was registered as CR case number
Clear case number 844.
CR case number 844 of 2007, 844/2007, arraying the respondent number 2 and 3 herein as accused. The cognizance was taken under section
Lordship, 448, 384,
448, 384,
506
506
and 34.
and 34. These are warrant procedure. The the accused petitioners appeared before the learned court and the prosecution proceeded full stop. Prosecution evidence was adduced, closed. Prosecution evidence. Prosecution adduced witnesses of as many as
I think 4, Lordship.
4 witnesses, which were duly cross-examined. And the matter duly examined. The accused person was examined under section 313 of the Code of Criminal Procedure on 14/12/2000 evidence. Full stop. On 14/12/2000, thereafter, on 14/10/2012, the accused respondent number 2 and 3 filed a petition under section 311 CRPC, which is quoted herein below, page
17, Lordship.
Huh?
17.
page 17. Page 17. Quoted herein below, page 17. However, on the same date, as reflected, you see is
15.
page 18, huh? Now, where is that withdrawal?
15, Lordship. Page 15. That petition is earlier. Page 15.
14/12/2010.
Page 15. Next page is 16.
File an application on 14/12/2010, na? Registered as petition number 3058/2010, which is quoted herein below. Okay. However, on the same date, as recorded in the petition itself, the said petition was not praised by the learned counsel. Okay. Quoted herein below, there is a type copy. You also see page 16. You type this part also. Page 16. That part also you type it. Could not recross preferred and petition to adduce evidence. I have written recross examination, adduce.
No, Lordship, the submitted list of witnesses. List of different witnesses.
Submitted a list of witnesses.
Different.
First petition 14/12, list of witnesses. However, the same petition was withdrawn on the same date. Subsequently, on the same date, another application was filed under section 311 of the CRPC to recross examine the prosecution witnesses, which was registered as petition number 3070/2010. Earlier was 3058. Okay, 3070, page 17, which is also quoted herein below. The learned magistrate, after hearing the learned counsel for the parties, dismissed the petition number 3070, is that it?
Yes, Lord.
3070/2010 on the ground that the said petition is filed without any ground, and that simply stating that some material points have been remain uncrossed will amount to filling up of lacuna. Okay, filling up the lacuna. However, at the penultimate paragraph, the learned magistrate fixed the matter for examination of defense witnesses on 2/11/2012. The accused respondent number 2 and 3 being aggrieved by the order dated 19/10/2012 preferred criminal revision petition number
12.
Huh?
62.
62 of
12.
2012, and at the same time the complainant preferred criminal revision petition number
12.
55/2012, assailing the part of the order whereby the matter was fixed for DW on 2/11/2012, fixing for DW on 2/11/2012, even after withdrawal of the application a list of witnesses. Full stop. The learned session judge took up both the matters together and passed the impugned judgment. It is seen from the impugned judgment that placing reliance of the determination made by the Honorable Apex Court in the case of
P. Sanjeeva Rao.
where is that?
Lordship, page 31. Top.
P. Sanjeeva Rao versus State of Andhra Pradesh, and a decision of this court some decision of this court has concluded that the learned SDGM within bracket S Morigaon failed to examine the matter judicially and pass the impugned order mechanically, which is not tenable in law. Full stop. And accordingly remanded the matter to the learned court below with a direction to allow the accused persons for further cross-examination of the prosecution witnesses, and points were also determined on the basis of the limited points which were mentioned in the criminal revision petition. Full stop. This court is of section. It is true that in the case of Suensu Supra, the Honorable Apex Court has laid down the principle as regards laid down the principles and parameters for exercise of power under section 311 CRPC. CRPC. However, the learned revisional court has not recorded any of its conclusion how the principle laid down in the Sanjeev Rao's within bracket Supra case is made applicable in the given facts of the present case. It is true that denial of an opportunity to call a witness for cross-examination may amount to condemning the person without giving him an opportunity to challenge the correctness of the person. However, it is equally well settled that cross-examination cannot be granted on mere asking of it. In the case in hand, by filing the petition number so and so, the petition number
3070.
3070
10.
2010, the petitioner simply filed an application and asked and prayed for re-examination. No reasons whatsoever cited in that case. Subsequently, before the learned session judge, the grounds that the earlier lawyer could not properly cross-examine the witnesses were taken, and accordingly same was allowed by the learned session judge by its impugn order. However, only on the ground, however, such application cannot be allowed only for the reason that the lawyer was inefficient and he could not properly cross-examine the witnesses and miss some vital points. Full stop. Thus, allowing such an application will amount to fill up the lacuna which is not the purpose and object of enactment of section 311 CRPC. That being the position, this court is of the view that the learned session judge has committed regarding illegality so far relating to allowing recross examination of the prosecution witnesses which has already been examined, cross-examined and discharged. Accordingly, the impugn order dated so and so stand set aside. However, so far relating to examination of the defense witness, fixing the date for examination of defense witness, this court would not incline to interfere with the said order, in as much as even in absence of the list of witness, the defense could not be deprived of its rights to its defense evidence. Accordingly, the present revision petition stands allowed with the aforesaid direction. LCR, not LCR, okay.
On the scan copy.
Scan copies. A copy of the order be communicated to the learned trial court so that learned trial court can proceed in the matter in terms of its order dated last order
1910-2012.
1910-2012. That order were fixing 1910-2012.
Item number 8, Lordship, there is a crossing of GR proceeding, Lordship, that LCR is not available.
Adjourn for the day.
Okay.
If council is not,
What are you saying?
LCR is not available, Lordship. LCR is
LCR is required. Conviction against conviction.
No, Lordship, crossing of GR proceeding, Lordship, GR case, Lordship.
Scan copies.
Can go is required, Lordship.
On the prayer of the learned counsel for the petitioner, search sheet is filed already.
Yes.
Learned counsel for the petitioner, matter stands adjourned. Full stop. Registry to call for the scan copies of record of GR case number. Scan copies of. Where is the search sheet? Annex 4. You are without the brief. Who is your senior?
senior council BD.
Huh?
In cost cycle.
Hmm. GR case number 1430/2013 from the Court of Chief Judicial Magistrate arising out of which PS case number? Arising out of Tunmati PS case number 64 of 2013 be called for. Is this matter again on February, huh? January, huh? 29th of January.
Process is going on, lawsuit, with the information.
Third compromise proceeding.
Respondent counsel. Regarding all of quashing of a share.
Huh?
Quashing of a share.
Yes, tell us. Compromise done or not?
Done, my lord, process is going on, lawsuit.
When? CR case,
Yes.
defamation
Yes.
between
In the petitioner and respondent number 2, lawsuit.
you are for
For a petitioner,
petitioner.
for the respondent number 2, my lord,
You fight there. Take instruction and compromise it. We are not keeping it day after tomorrow. Friday. 20. Yes, Mr. Talukdar. Any urgency?
This is not there. Again, the quashing of defamation case, lawsuit.
Quashing of defamation. Who are you?
I am
for the
complainant, lawsuit.
What kind of
Basically,
defamation?
dispute between the president and secretary. I was the secretary, he was the president of society.
What is the society? Defame where?
Page in the WhatsApp group between the
Page
flat
20,
owners.
lawsuit.
Yes.
Between the flat
Page
owners.
20, lawsuit.
Let me finish.
Still you are fighting?
Yes, lawsuit, but the word they have used, lawsuit, he has used, lawsuit.
What
Among
is
the
it?
WhatsApp group, because there was enmity between them, he has filed case against me, FIR against me. I also filed a case. That will also can see annexed to page 25, the initial statement. That will suffice everything. I am a retired officer. I am an engineer by profession. Presently, I have small construction business. I had purchased a flat in Megamola apartment. After purchasing the flat, became the owner. There was a society in the apartment since I was
Now
tenant.
society is fight gone to courts.
Don't quote.
Where is the defamation? Let us see.
In that part, because they have formed one WhatsApp group.
Now
No,
where is the statement as regards
Statement that
the-
I am in from the page 20.
no, paste
Page 20.
in a complaint?
In the complaint. You are most welcome to discuss, but I have lost interest seeing the selfish interest of all, hence requested to decide replacement. Replacement as regards the president and all.
Okay.
But definitely Bastard Dixit has to name,
Yes.
has to name and prove it, and I will refrain from paying, sir. That, because the word bastard was there, therefore he has filed it.
What is the defamation, meaning of defamation?
To harm his reputation, imputation must be there.
Before?
Before public.
Now what is the
This is a WhatsApp group between the flat owners.
initial defamation? Initial statement?
Initial statement now will come. Is 25 it starts. 26 your loss may directly come. Thereafter some second para. There was some incident occurred and society sent those people directly to me without.
Now, where is the other statement? Only one statement.
Only one.
They are on the basis of that cognizance. Where is the defamation?
Because that word lordship.
Before whom? Where is your witness?
Lordship, this lordship, on the first day they have come lordship.
Ah,
On the
that-
first day they have taken the lordship.
See,
After cognizance I have come.
Lordship,
cognizance has been taken
yes, lordship.
I have come.
on the basis of evidence. Please show us on the basis of material and statement, where is the
Before whom
defamation?
he was defamed.
Actually, case has been made out.
No, no, please tell us what is the defamation, meaning
They,
there.
may I take lordship 499 lordship? I think.
499. Definition. Here you use the language, Durlabh Sokya, abuse me on WhatsApp using obscene language. That's the only name.
May I read lordship?
Please read.
Whoever
Hmm.
by word
Ah.
either spoken or intend to be read, that is.
No, no, fine, forget it. Everything is there.
Yeah,
Read,
by
read further.
by sign or visible representation make or publish any imputations concern any person intent to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said, except in the case, in the cases hereinafter expected to be defamed that person.
Yes.
Now, lordship, exception is there.
Hmm.
1, 2, 3, 4, lordship, exception is there. Now, lordship, that part I am on that part, lordship, spoken or intent to be read.
No, no, I may speak anything, I may speak anything. What do you mean by, what is the definition of defamation? Defamation is before whom?
Public.
This is a group they have created.
Understand,
Insist
everything
everyone to
is
read,
accepted that this is a group. For your word, I have been defamed.
Yes, lordship.
I have been defamed.
Yes, lordship. I have a reputed person, lordship.
You
I'm
are
a
a
retired
see,
colonel.
two
Yes.
things. One is you are a reputed person, that
Yes.
your reputation has been defamed before whom? In the eyes and esteems of the others, member of the public,
Others member in that group, lordship.
in that group.
Group.
Where
Because
is
they
the
have just-
evidence of any of the in the member
that
of in that
before
group?
that, They have approached. lordship.
Cognizance taken. Cognizance could not have been taken on the basis of this material. That's all. On the prayer of the learned counsel for the respondent, matter stands adjourned and be listed after vacation. Please satisfy that. What is the procedure when a cognizance can be taken? You file a complaint.
Yes, lordship.
You will have to satisfy the magistrate by that initial evidence.
My reputation is harmed.
Your reputation is harmed. What? Please let for the legal debate. Don't be so excited. Please read something.
Yes.
The question is, defamation is always before the eyes and esteems of others.
Yes.
I cannot say I have been defamed. My witness will have to come and say that, see, this man, I had a reputation of him. He was a very good man. But after reading this, his esteem has gone down to anything before me. That is the defamation. You cannot say that I have been defamed. Defamation cannot be like that. Defamation should be
supported
by
by-
somebody else. Defamation is not in the eyes and esteems of myself. Defamation in the eyes and esteems of others. That is the level. If you want to please,
Yes.
if you want to go through something,
Yes.
or I will take you the judgments before you right now.
Then after vacation, lordship.
If you are
after-
so confident, I can now right now give a judgment on that. Hello, itna muझे delivery कुछ judgment. That petitioner in person. Defamation. You want?
After vacation, I'll convince lordship there.
Please first convince what do you mean by defamation and what the
Yes,
Supreme Court has said,
Yes.
how a defamation is done. That's all, because it's a tortious libel.
Definitely. 20.
Can it be 20 or 22?
20.
High level.
Yes, Alam.
Is that
Interim order pass earlier shall continue until further orders. Yes, Alam.
Yes, Lordship.
Tell us.
Here in this case, petitioner daughter, minor daughter was forcefully taken away by respondent number 2. Thereafter, one NGO, they lost an affair. Trial was almost over. It was fixed for argument. Now, the petitioner, the father of the victim, he filed a petition for examining the headmaster of the school where he was admitted. Because birth certificate shows that on the alleged day of
It was under POCSO.
No, no charge of POSCO, only 366, even not 366A. Charge was claimed under section 366. So the respondent number has, two has committed much heavier offense. Then he was.
Who is for respondent number 2?
Actually, we filed a affidavit also.
No,
by
no,
order
name is
to-
also shown, NK Haloi PC Sarkar. So you want that re-examination of sub? No.
As a court witness, the headmaster of the school where she was
It was a GR case.
there case.
Okay, we'll take up after vacation. No? Since she,
Unfortunately, the victim, she committed suicide after the incident, 3 months of the incident. She could not bear the humiliation. So date of birth, the negligence on the part of IODET, and during investigation, they did not seize the birth certificate. So court mechanically framed the charge under 366. Had it been POSCO,
okay, we'll take up this matter after vacation. It's an important issue.
after review, Lordship.
After view, none, this is item number?
12.
Though name of the respondent are reflected in the cause list, however, none appears from the for the respondent number 2. As this, if this petition is allowed in favor of the petitioner, the said respondents may be infected, and therefore this court would not like to proceed further in absence of the learned counsel for the parties. Accordingly, list this matter 27th of so. In the event on the next date none appears, this court may proceed either in absence of the said counsel or may take assistance of amicus curiae. None appears for the petitioner on call. List this matter in the first week of February 2025 on a date to be fixed by registry.
Passport a matter for the time being. Mr. Sharma is on the way.
List this matter after vacation 2019 on in the first week of February 2025 on a date to be fixed by registry. That's all. Vacation mode.